In this video, we will deal with the definition of state under Article 12. So the part 3 of the Constitution deals with the fundamental rights, but actual fundamental rights starts from Article 14 and it ends with 32. So part 3 comprises of fundamental rights, and those fundamental rights are dealt under Article 12 to 35. That is the whole of the part 3, but the actual fundamental rights are dealt under Article that is 14 to 32. So those articles are the articles that we mostly cite, but there are other articles as well, such as Article 12, 13, 33, and 34, 35. All these articles support the actual fundamental rights. So now a question might arise as to why are we learning Article 12, and what is the purpose behind knowing what are the authorities that come under state and what not. Trust me guys, it's really important to know what are the authorities that come under Article 12, because every fundamental right that are provided in the article that is under this part, if they are violated, we cannot initiate a proceeding against the private body. We can only file a writ petition before the court for the violation of fundamental rights only against the state, that is government. So the place in which the state has been defined is Article 12. So it is really important as to determine what are the authorities that come under the state. So what is Article 12? Definition has been given under Article 12. What is the actual definition? So I'll read the definition. In this part, unless the context otherwise requires, the state includes government and parliament of India, and the government and the legislature of each of the states, and all local or other authorities within the territory of India under the control of the government of India. So that is the whole definition. To simply put, executive and legislature of the union and the state, and local authorities within the territory of India, and which are under the control of government of India. So all these authorities mostly come under the ambit of state. So in order to define a legislature and executive, uh, we have to categorize them into union and the state. Like president, Lok Sabha and Rajya Sabha will be the part of union legislature, and governor, state legislative assembly, and the state legislative council will be the part of state legislature. When it comes to executives, a president, vice president, and the council of ministers with the prime minister will come under the union executive, and the governor, council of ministers with the chief minister has the head will come under the state executive. So now a question might arise in everyone's mind regarding judiciary, because we have left it out along with the legislative and executive, because of course the third pillar will be judiciary, right? So the question would be rising is whether judiciary will come under the ambit of state. So the answer is quite controversial, because uh, the Supreme Court has never said that the judiciary will come under the ambit of state, but the Supreme Court has also said that while acting judicially, the Supreme Court would not fall under the definition of state, but when it performs any administrative functions like conducting examinations, right? So in such cases alone, like in administrative uh, capacity, they will come under the definition of state. But it's quite controversial, and remedy can be sought with regard to conducting examinations and issues of such nature. In such case, when the fundamental rights are violated, the courts doors are open to file a writ petition. So that's about the legislature and the executive. Now comes the local authority and other authorities. So the local authority is defined under section 3 clause 31 of General Clauses Act 1897. So I'll read the whole definition that is given. Local authority shall mean a municipal committee, district board, body of commissioner, or other authority legally entitled to or entrusted by the government with the control or management of a municipal or local fund. The definition is clear, right? Uh, to simply put, any authorities that are within the local limits, such as municipal bodies, panchayat, is ought to be considered as a local authority, right? So it's never a dispute as to what comes under the local authority, but there was always a dispute regarding the term other authorities, like the term that is mentioned in the definition. So what is this other authority? What are the other authorities that would come under uh, the definition of Article 12? So this gray area arises because the term other authorities are not mentioned in the Constitution. If it was mentioned, it would have been quite better, because we might have a clear cut idea as to what will come under the other authorities under Article 12. So it has always been a dispute regarding what comes under the ambit of other authorities, and Supreme Court had rendered so many judgments over the years regarding this. So we will discuss the cases one by one in this video. So the first case is University of Madras versus Shantibai. So the case revolves around a problem where there are certain guidelines that have been issued regarding the admission of female candidates into the university, and it seemed like violating Article 15, right, which explains that based on sex, no one can be discriminated, right? So the court has applied the principles of justum generis in this particular case. Justum generis means same kind. That is the literal translation. It is a Latin word. So it is a principle that is applicable. And in case of Article 12, like other authorities such as legislature, executive, and local bodies, when we incorporate justum generis principles into this discussion, the other authorities that stated in the provision simply means the other authorities that perform similar functions like legislature, executive, and local bodies. So other authorities simply means, according to this doctrine, the authorities that performs the similar functions identical to legislature, executive, and local bodies. So basically, the authorities that are performing governmental functions will come under the ambit of the other authorities. So the court in this case had held that the university is not performing any sort of government functions, and therefore it is held that in this case by the judges, the universities will not come under the ambit of Article 12, and the case against the state was not maintained in this case, that is University of Madras versus Shantabai. And then comes the case Hujjambai versus state of UP. So in this case, the court observed that incorporating justum generis, uh, the previous case, that is University of Madras, had so much to talk about the justum generis, right? The court in this case had totally ruled out the application of a justum generis principle with regard to determining an authority under Article 12 or not. So in this particular case, the application of a justum generis principle was totally ruled out. So here the common genus was the main thing, the main reason that has been cited by the court, because the other authorities, like in the sense the legislature, local government, and the executives are not do not share the same genus. In such case, I mean, the court has opined that you can apply justum generis principle only if there is a common genus. If there is no common genus, one cannot apply justum generis principle. This was the court opinion, and therefore the application of justum generis principle was totally ruled out in this case. And then comes the next case, that is Rajasthan Electrical Board versus Mohanlal. So this was a promotion related dispute, claiming that Article 14 and 16 has been violated because the discrimination was regarding promotion, which was alleged in this case. But so the claim is that to apply the principle of justum generis. So here the claim was totally to revert back, right, to make this Ujjambai judgment redundant. And the petitioners in this case have approached the court saying you have to apply justum generis principle so and so. But because the previous court had already ruled out the application of justum generis principle, in this particular case, the court had held that all bodies that were created by reason of a statute. So now we are talking like statute comes into the picture, and if the court is satisfied that it performs a governmental or quasi governmental functions, then in such case we can safely assume that that authority will come under the ambit of state. So in this case, Rajasthan State Electricity Board was declared to be a state. The court was satisfied that it performs a governmental or quasi governmental function. That is the keyword in this particular case. And the next case is Sukhdev versus Bhagatram. So in this case, the court declared that LIC, Life Insurance Corporation, and IFC, Industrial Finance Corporation, and ONGC to be a state because the court was satisfied, in fact, that they were functioning, they were performing functions very close to the governmental functions, and therefore the court came with this conclusion like they have declared LIC, IFC, and ONGC to be a state. So the outcome of this case is that the authorities that performs governmental or sovereign functions may come under the ambit of Article 12. And next comes the case that is Subhajit Tiwari versus Union of India. So the dispute in this case was that whether CSIR, that is Council of Scientific and Industrial Research, whether it will come under the ambit of state under Article 12. So it is important to note that both Sukhdev case and Sabajit case was heard by the same bench. Okay, and in this particular case, that is Subhajit Tiwari, the court held that CSIR will not come under the ambit of state, even though it is created by Government of India and it has been promoted to industrial research, even though the majority of the members were nominated by the central government, in fact, and most of its financial requirements were supplied by the government. All this being said, the court still was in the opinion that the CSIR will not come under the definition of Article 12. So the reason that has been given by the court in this case is that it does not have a statutory character like ONGC, LIC, or IFC, and therefore it has been held that CSIR is not a state under Article 12. And next comes the RD Shetty versus International Airport Authority. This case is very important. So before this case rolled out, there was a lack of clarity as to what doctrine to apply and whether we should apply any principle in order to determine authorities under Article 12. But after this case, there has been some sort of light that has been thrown out and some sort of clarity in order to determine authorities that come under, whether they come under state or not, has been given. The clarity has been given. So some of the essential characters that has been cited in this RD Shetty cases are the government share capital, right? If the entire share capital is held by the government, in such case, of course, that entity will be coming under the ambit of state, and the amount of financial assistance that is aided. So if the government is providing some sort of financial assistance and that sum of financial assistance is more than sufficient to meet the entire expenditure, so in such case that expenditure incurring authority will come under the ambit of state. That is the second criteria, that is financial assistance. And when the state has a deep and pervasive control, this is very important. If the government has a deep control over any entity, that will come under the state as well. And the functions such and the functions like of that corporation is that of public importance and is closely related to governmental functions, then that entity will be a state, right? And monopoly status, if that entity enjoys a monopoly status, the monopoly status can be conferred either by the state or it may have gained it. So in such case, if such entity is given has been conferred any monopoly status, it will come under the state's definition under Article 12. Next comes the Som Prakash versus Union of India case. Yeah, this case. So in this case, the court has held that uh, any public authority, if it performs a public function, the public function is the keyword here, and if it performs duties and carries out its transaction, that in turn benefits the state. So the entity is performing a duty and it is carrying out transactions that reflects the benefit of the public, and not just the public but also the state. In such cases, those entities will be brought under the ambit of state. And in this case, similarly, Indian Petroleum Corporation has been declared as a state in this case. That is one thing to remember. And now comes Ajay Asya versus Khalid Mujib. So the court has approved the test that has been laid down in R.D. Shetty case, right? But the court also gave some opinions saying that the guidelines that have been given in R.D. Shetty case is not conclusive. Of course, they can be used in order to determine, and they may be a good framework, but it is not a conclusive thing, right? It may be subject to the facts finally. And the court also said that those guidelines must be used with care and caution. So basically, the facts uh, the facts of the case is that it revolves around an education institution. So the core question before the court was that whether to bring an education institution under the ambit of state or not. That was the central question in Ajay Asya case. So the court declared that education institution will come under the ambit of Article 12, right? So that is regional engineering college that is located in Srinagar. So the court declared that the educational institution will come under the ambit of state. And next comes the ninth case, that is Chandra Mohan Khanna versus NCRT. This case, the court refused to admit that NCRT to be a state under Article 12, and the reason that they have cited is that the NCRT does not perform any functions of the government, and therefore it is not a state. So this was the reason that has been given by the court. This particular case, that is Chandra Mohan Khanna. Next comes the Pradeep Kumar Biswas versus Indian Institute of Chemical Biology. This is a 2002 case, as it mentioned here. So in this case, it was decided that ultimate test in determining whether an entity falls under state or not depends on the pervasive control of the state regarding the entity's function, financial and administrative controls, right? So if the government has control over such entity, not just the normal control, it should have a pervasive control, then such entity can be declared as state. And the last case is that Z Telefilms versus Union of India. So the court decided that BCCI will not come under the definition of state under Article 12 as it does not satisfy any of the criteria. And that being said, in fact, the BCCI is not at all financially dependent on the government, and the government also did not have much control over it. As we discussed before, the previous case, the government should have a pervasive control over a particular entity. Only then it shall be declared as a state. So BCI being not financially dependent on the government, the court ruled that BCCI will not come under the ambit of state under Article 12. But there were some dissenting opinions that have been given by other judges. They found BCCI to be a state because it performs an important public function. That was the dissenting opinion in this particular case. But BCCI still remains as a private entity, and it does not qualify to become a state based on the criteria laid down. Yeah, that was the outcome of this case. And these are the key takeaways that I've mentioned here. We have started the case laws from Justum Generis, and in R.D. Shetty case, there have been so many essential characteristics has been declared. So R.D. Shetty case is really important, and the Z film case, right? So basically, the government should have a pervasive control over that entity. Maybe it could be on basis of share capital or financial dependency or administrative control. The government should have a pervasive control over that entity. Only then that entity will be declared as a state under Article 12.